All right. Well, we seem to have a good number of participants already, so I think I'll just go ahead and get started so we can get to all the information we want to get through. As Nancy off screen just just mentioned, the screen that you're seeing right now is just information about how to get more involved, and if you're so inclined to donate to Death Penalty Focus. As Nancy said, it's a nonprofit organization, and the donations make it possible for us to put on webinars like the series that you're watching right now. And just to introduce myself, since I know Nancy has moderated the two webinars before this, my name is Schaefer, and I'm so pleased that so many people have been able to join the webinars to date and are joining today. I am on the board of directors for Death Penalty Focus, and in my day job, I am a staff attorney with the American Bar Association's Death Penalty Representation Project. And I'm really thrilled to be speaking with all of you today. And I just want to I'm going to stop screen sharing for just a second, because hopefully you have that info, and I'll put that screen back up at the end if you need that. So just to do a little administrative housekeeping, since I'm moderating today, the way I'm planning on running the webinar is to host basically a panel discussion with our two amazing panelists who I'm going to introduce in a minute. And then to try and keep the Q&A try and keep about 15 minutes at the end to talk through audience questions. If you have questions as the panelists are talking, as we're discussing, if you could put them in the Q&A option at the bottom, the Q&A chat. That's confusing, but not the chat, the Q&A. That's where we will see it. To the extent that I'm able to really multitask and see the questions as the conversation is going on, and if they are relevant to what we're discussing, I might chime in with some of the audience questions. Otherwise, I will just collect them to discuss at the end of the presentation. And also, before we start, I just want to give a little framing for what I'm hoping we're going to talk about today. So we've been doing this webinar series with the hope of talking to some of the myths and misperceptions, what we would consider, about the death penalty. I think there's a lot of information out there that is sort of hard to parse and hard to process, and it's a very complicated area of law, obviously. And I think to really understand it and to come to a place where you can feel secure in your opinions about it, you need to have sort of a good sense of how the process works, and how mistakes get made along the way in the process. This is something that those of us who work in this area know that does happen, that mistakes do get made, but I think there's a lot of legitimate questions out there as to how does that happen in something so significant like a death penalty case. So we want to talk about that today. So let me introduce our fantastic panelists. We have Emily Loson-Gault, who is the director of the ABA's Death Penalty Representation Project. So she is my supervisor. So thank you, Emily, for agreeing to join this webinar today and to speak with us.
Absolutely, happy to be here.
And then we also have Rob Dunham, who's the executive director of the Death Penalty Information Center, commonly referred to as DPIC. And for those of you who are interested in death penalty issues or who sort of follow this issue closely, I'm sure you're familiar with DPIC. It's a fantastic resource for just learning more about death penalty cases, for analysis, for basically as much information as you could possibly want about how the different state processes work and how the federal death penalty processes work. So he is an incredible resource. The website is an incredible resource. So thank you, Rob, for agreeing to speak with us.
Thank you for having me, and thank you to both the Death Penalty Focus and the ABA Death Penalty Representation Project.
Absolutely. And the way I want to structure this, because I think it sort of gets to what I was mentioning, that there are a lot of complicated aspects to death penalty cases, but one way that sort of helps us cut through that is to figure out, okay, how does the process work, sort of soup to nuts? And I think having an understanding of that lets us then sort of home in on some of the issues where the problems arise and how things go wrong in a process that is so significant in our criminal justice system. So the way I'm planning to divide this is into questions around the trial, what happens at the start of a death penalty process, and then get a little bit into the process questions, which is going to be going through sort of appeals and how it moves through the judicial system, and then hopefully talk a little bit about, what are ways we can fix this. This is still a system that we have in this country. What are the types of interventions that could be made, or can interventions be made to address the problems we're going to identify? And if other things come up, we'll address them, but that's sort of how I'm planning to structure this. So with that, I will stop my introductions and I will ask my first very broad question in the topic of, let's just get started, soup to nuts. Let's say you are accused of a capital crime. You are charged, indicted with a crime that carries with it the potential of execution. How does the process start? How do you get an attorney? How is one provided for you? Do you always have an option of who your attorney is? Let's start by talking about representation. So, Emily.
Sure. Thanks, Laura, and thanks to Death Penalty Focus for having me here. Very happy to be joined by some wonderful colleagues for this presentation. So big question with very broad answers, but essentially how you get a lawyer at the start of your case depends on whether you can pay for one or not. And that's something that unfortunately determines how your case is going to move forward through probably the rest of the process. So if you can pay for a lawyer, if you have the means to go out and hire a private attorney, then you have a constitutional right to the counsel of your choice. The US Supreme Court has said that that is embedded in the Sixth Amendment, that you get to choose your lawyer. If like most criminal defendants, you do not have the ability to pay for a lawyer, however, you have no right to counsel of choice. So that constitutional right depends solely on whether or not you are paying for the lawyer or not. And if you're not, then your court is going to appoint you a lawyer. You'll have to prove that you meet a certain requirement for indigency, that you can't afford a lawyer yourself, and then you'll be appointed a lawyer. And who that lawyer is, with very rare exceptions, you have no say over. And if you're lucky, you might get a great lawyer. You might get someone from a terrific public defender's office. Here in DC where I am, we have a world-renowned public defender's office that has incredible training, resources, staff, not just lawyers, but support staff, assistants, investigators, specialists. If you're not lucky, you might get someone who doesn't have a lot of training, doesn't necessarily know what they're doing, it's especially in the context of capital cases, and perhaps even more importantly, might not have the resources they need to adequately represent you. And it's really a product of luck and geography where you are, whether or not that happens.
And we know that this makes a huge difference because those of you in Los Angeles know that most of the capital cases go to the Los Angeles Public Defender's Office, which is a very good office. And there are sometimes conflicts, and so then when there's a conflict, it goes to conflict office, and they're pretty good too. And then if they're both conflicted out, which is the case fairly frequently, then it goes to a court appointment process. And Los Angeles has the largest death row of any county in the United States. It's got more than 200 folks on death row. And when we look at the percentages of who's there, we find that a hugely disproportionate percentage of the people on death row from Los Angeles are the people who end up getting the court-appointed counsel. They don't have the institutional resources. They don't have the investigators on staff. They're dependent upon the court to provide them the resources. And we find in those instances, just like we see across the country, when the court has control of the purse strings in a capital case, the quality of investigation is much worse. And if you have to tell the court what your strategy is going to be in order to get your investigator, you end up compromising your ability to provide a defense. But that is the case over and over across the country. The greatest experiment, natural experiment in this was my home city in Philadelphia, where the public defender's office is terrific and the court appointment process is horrendous. And the public defenders are permitted to handle only 20% of the cases. Since this started in the 1990s, there have been 90 people who've gone to death row from Philadelphia. And if counsel made no difference, then you would expect that 20% of them, about 18 people represented by the public defender, would have gone to death row. They have 0. So we know that counsel makes a difference. And the scariest thing is the rules for appointment are different in every state. In some places, they're different in every county. And we know that counties are outliers who would disproportionately account for who is on death row. We find that the appointment process in these outliers tends to be worse than everywhere else. The judges who are making the appointments in many of those jurisdictions come out of a prosecutorial culture, and they've been previously, they served as district attorneys before they were elected. And so the appointment process is skewed, the resource process is skewed. And we find that those jurisdictions tend to have more prosecutorial misconduct, less qualified counsel, and judges who tolerate those inequities. So, the process for getting counsel is tied into everything else, and it is part of what's so arbitrary about the death penalty in the United States.
So one thing that just immediately comes to mind from hearing both of your answers is I think there's a perception, which may be a misperception, that public defenders are always going to be the most overwhelmed actors in the system, that they're always going to be under-resourced, that you're always going to be worse off if you end up with a publicly funded counsel, a public defender, than a different type of attorney. And I'm wondering if you could speak to that a little bit. This is something that we in the death penalty world talk about as institutional defenders versus court-appointed counsel, but I think that's not something necessarily that's immediately obvious to people what that means and what a court-appointed attorney is versus an attorney who works in a public defender office. So I guess I have 2 parts to my question. The first is that perception about public defender offices always being overwhelmed, is that fair? Is that true? And the second being, can we just define what the court-appointed attorney means versus an institutional defender? Emily, do you want to start out with?
Sure, I can start out, and I'm sure Rob can jump in and add a lot to this. So first of all, public defenders are massively overworked, and I don't want to imply in any way that they are not. There is a huge nationwide lack of funding, and in certain places it's worse than others. Louisiana right now is in absolute crisis for lack of funding for their public defender program. Now, that said, you're not necessarily worse off because you get a public defender. And Rob just talked about the Los Angeles public defender. I talked about the DC public defender. There are great public defender offices out there that have extraordinary attorneys, extraordinary staff, extraordinary investigators and specialists who will provide outstanding representation. And an appointed attorney might be someone who is on a list that is maintained by the courts, that meets some qualification standards that state has set. Now, there are no standardized qualification standards across the United States. My organization, the Death Penalty Representation Project and the ABA as a whole, has put forth guidelines for what standards should be, what the minimum qualification should be, and we're happy to have a lot of states follow those, but just as many don't. And some of the highest use death penalty states don't follow those standards, have implemented their own, and they might be as simple as you're a member of the bar. And if you receive an appointed attorney who doesn't work at an office that has its own standards for hiring and training and making sure that your lawyers know what they're doing, you could very well end up with someone who doesn't have training, who doesn't have experience. And again, going back to what I said before, doesn't have the resources that they need. Because if you're fortunate enough to be appointed a public defender from an office that receives at least some sort of state funding or city funding, however it's organized, and has a budget to conduct an investigation, has a mitigation specialist on staff who can go out and prepare the case for life for your client, that's completely different than someone who is a solo practitioner on their own, meets whatever qualification standards that might be set in that jurisdiction, but might receive minimal or no funding and has to go, as Rob said, to the judge every time they want more funding and request it. And that presents all sorts of problems with having to disclose your strategy, but also judges routinely deny those requests. And so the reality is you might end up being a lot better off with a public defender than an appointed attorney, but it varies so much place to place that there's no hard and fast rule whatsoever. And it really is an arbitrary thing whether you're going to end up with the kind of representation you need to have a fair trial.
And there are all sorts of structural impediments as well. How you get to be a public defender and what a public defender does and how they work doesn't just differ from state to state, it differs from county to county. Where there's no state public defender system, you have some offices in which there are full-time public defenders. And in the offices with full-time public defenders, sometimes there are ones who specialize. So you have homicide units. And when we're talking about homicide units, you get more down to the institutional capital defenders who have expertise in this and have staff that are well-trained, not necessarily well-resourced, but they know how to use the resources a whole lot better. When you have counties that have part-time public defenders, you have folks who are not only overworked, but they're not being adequately compensated. And they're being paid so little that they have to have other jobs just in order to make the ends meet. If you're in that situation, you've created an economic conflict of interest when the part-time public defender has to handle a capital case. Because there is no way that you're going to be able to do that, provide the amount of hours that are necessary, and be able to subsist. There are also, and the ABA has filed suit on this. There are circumstances in which there's conflict counsel who gets appointed, or contract counsel who gets appointed, and many times these offices are on a fixed budget, so you get paid a certain amount for an entire year, and that it's not all capital cases. It's very few capital cases. But if you're being reimbursed on a flat fee basis, a flat amount basis for a year, and you have a capital case, then you are not going to be able to do your job. Those are setups that the ABA says are inherently unethical. They violate the right to zealous representation because there is always a conflict when somebody's ability to keep themselves alive interferes with their ability to provide meaningful representation. These are huge problems, and there are political dimensions to it as well, because we have a very good institutional defender in Georgia, but there is an effort right now to defund or underfund. And every time we have economic problems statewide or nationwide, you see money being taken out of public defender budgets. You might have a Lamborghini quality driver. You might even have a Lamborghini quality car. But if you do not have electricity or gas, it isn't going to go anywhere. And that is a systemic problem across the country.
And one question that just came up in the Q&A that I think you can just quickly address, but could you explain what would happen for a case to be taken out of the public defender office and be moved to conflict or contract counsel, as you were saying? What are the circumstances that create for that?
Well, there are a range of circumstances. The most common one is that there is a conflict because they're co-defendants. There could also be a conflict because at some time in the past, the public defender's office has represented someone in the victim's family, that they've represented one of the witnesses, they've represented one of the co-defendants in some other matter. So they can be conflicted out. They can also be conflicted out because they are so overworked that they don't have the capacity to take on additional cases. And when that happens, then the Constitution provides that you have a right to counsel, but the court pretty much decides. Or the county commissioners will do it by the kind of contract system that we talked about.
And so I think we touched on this briefly, but can you talk a little bit, both of you, just about the impact that you see in the cases coming through the system from how the representation plays out at the at the start. So basically, do we see consequences for death penalty cases depending on where the representation comes from, and whether it's assigned to institutional defenders, court-appointed counsel. I'm thinking also, Emily, a little bit about just sort of how things are changing in the cases we see that come to us for pro bono placement as systems change. That's sort of what I thought would be interesting to discuss for a minute.
Yeah, I mean, I wouldn't, again, I don't want to make generalizations because things vary so much between jurisdictions. The ABA recommends an institutional defender system. The ABA recommends that you have a dedicated office with people who have met qualification standards and who have staff support. So that model is the better model speaking very broadly. And we do see, I think, generally better outcomes, assuming, again, that those offices are properly staffed and provided proper funding. But in terms of the impact, I mean, whether or not it's an institutional defender office, a contract counsel, appointed counsel off some registry, the quality of counsel is really the determining factor. And in quality, I'm also incorporating the resources that are provided to counsel. So this isn't me necessarily saying that these lawyers are all unqualified or aren't trying, but like Rob said, maybe they don't have the gas, they don't have the energy to make their car go. And there's nothing they can do about that. And that is a major determining factor of the outcome of the whole rest of the case. Justice Ginsburg very famously many years ago said that people who have good counsel don't get the death penalty. And she based that on the fact that all the eve of execution applications that she had seen over and over and over again, none of those people had good lawyers. And I mean, that observation coming from a United States Supreme Court justice is really striking. It's what we see certainly in our work, but they're seeing it at the very top too, at the end of the line with these cases, that over and over and over again, the ones that don't work out, the ones that make it all the way to execution are the ones where the person didn't have good lawyers at the beginning. So if you don't have a good lawyer from the start, it impacts everything all the way to the end.
And oh, sorry, Rob, maybe you can speak to this, but I just wanted to really drill down on exactly that point that Emily was saying and sort of get to the broader question of why does it matter? What happens in a death penalty case, or what needs to happen in a death penalty case for us to feel that it could be a fair and reliable outcome? What happens at the trial? What is the money needed for? I think a lot of people have questions about the cost in death penalty cases. Why do we say it needs so much money? Why do we say you need to be able to fuel your Lamborghini, for example? So can you talk just a little bit about what the significance of that is and the work that they should be doing, that we want them to be doing?
Well, death penalty case is different from any other case. It's different not just because somebody's life is at stake, which is reason enough to require counsel to put in extra effort. It's different because the legal process is very different. A death penalty trial involves two stages. There's the guilt or innocence stage, and then there's the life or death stage. The evidence that gets presented in them is very different. Unlike anybody else, you have to be much more careful in what kind of defense you present in a capital case, because if you're convicted and the jury doesn't believe it, it may undercut the credibility of the case for life that you were intending to present. So in many respects, you have to prepare the case for life in advance of preparing the case for guilt or innocence. And the case for life involves taking an individual who the evidence, if the jury believes it, will have made them painted out as a monster who pretty much has intentionally taken somebody else's life. To do the proper investigation, and Emily can talk more about this because of the ABA standards, but it requires a multi-generational investigation of somebody's history, because I'll put this in real simplistic terms. The jury's going to want to know why your client committed the murder if they've convicted him or her. And simplistically, it was either in character or it was out of character. And if it was in character, you've got to explain what it was about the person's background, upbringing, mental health, mental conditions, problems with cognition, whatever it is that led to that. And if it was out of character, you've got to be able to explain the good aspects of the person's character and what it was about the circumstances of the offense that caused them to act so unusually based on the way they normally do. Both of those have psychiatric components. You would need a psychiatrist, a psychologist, and importantly, a neuropsychologist to talk about brain damage, brain development, and a whole range of things. And none of that is relevant in almost any other case.
And Emily, did you want to speak a little bit to the standards that the ABA has in terms of doing the work to prepare a death penalty case, doing the mitigation work, and also just getting to the very underlying question of why do we care about this? Why do we have these standards?
Sure. Well, I can answer your first question, or your second question first, which is why do we care? Because it makes a difference. Going back to what I said, if lawyers meet these standards, if they have the resources to follow these standards and do what needs to be done, by and large, with very rare exception, the client, we have found, doesn't get the death penalty. And that's because when jurors are exposed to the defendant as an entire person, as a whole person, like Rob was talking about, either what led them to have the type of personality or to be in the circumstances where they would commit this crime, or what led them to do something out of character, jurors decide that this person still has humanity and deserves to live. And that has been shown over and over and over again through decades of this practice and jury studies and experience of the capital defense community. And the guidelines are there, the American Bar Association guidelines are there to make sure that people get that baseline adequate defense, that they get that chance to tell their story and to be seen as a human being and let the jury make that decision. So that's why those guidelines exist. That's why we care, because they make a difference. They make a life or death difference in capital cases. Now, in terms of what they say about what needs to be done, I could spend the next, 3 days talking to you about what all needs to be done and what the guidelines say. They are dozens of pages long in their black letter text. They have hundreds of pages of commentary about all that needs to be done. But it's a process that takes not just a few days or weeks, it takes months or even years to complete adequately. It requires all sorts of different types of investigators. So you have an investigator or a team of investigators who are maybe doing a fact investigation about the circumstances of the crime. You have a separate investigative specialist known as a mitigation specialist whose skill is in learning that family history, finding out about this person, where did they come from, what is it in their background that makes them who they are. And it's not, like Rob said, it's not just that person, but it's their family. It's multi-generational. So you have to go back multiple generations and look at this person's family history. You have to look at their medical history. So do they have any medical problems, physiological problems that are causing issues, but then psychological problems. We also know that intellectual disability has a high prevalence of people who are sentenced to death. And so you have to look at whether or not there needs to be testing for disability that would make someone ineligible for the death penalty. And the key is you have to do it all at the front. So it's critical that all that evidence, anything that might make that one juror, just one juror, in every state now, just one juror, decide to vote for life, which they can do for any reason they want. You have to make sure that that evidence gets in at trial. Because if it isn't put in at trial, there is every roadblock in the world that will prevent you from putting it in later. And so the investigation that you conduct as a trial lawyer, as a trial defense attorney in a capital case, has to be the most comprehensive thing you can possibly imagine. And that takes time, and that takes money and expertise.
And one of the very basic principles you need to think about some of the most famous cases, the Aurora movie theater shooting, for example. That was a mitigation case that took weeks to present. And And Mr. Holmes ends up with a jury with 3 of the jurors saying that he should be sentenced to life. So he gets a life sentence. Now imagine if this case that took multiple weeks to present, instead you had a poor lawyer and you had a drive-by mental health evaluation. There's no question in a case like that you'd end up getting the death penalty. And if someone is dependent upon a court to tell them how much money they have, and they don't get to select their own expert, they may not get someone who's able to properly diagnose schizophrenia. They may not be able to get somebody who's able to diagnose bipolar disorder. They may get a run-of-the-mill doctor. When, if I needed brain surgery and I had to go to a court and they say, well, you get an expert, I'm going to appoint a podiatrist, there's nothing you can do about it. And it's the same kind of concept at work when it comes to the resources in capital cases.
Great. And I think Emily did a great job of moving us to what I think is going to be the next part of what we're going to talk about, which is basically the process. Okay, something goes wrong at trial, or at the very least, you come out of trial with issues you want to raise later on. Why is it so difficult to raise these issues? Why does it take so long? Before we get to the first question there, I just want to sort of summarize what we've learned with the first part of the webinar, just because I think it's important to differentiate the 2 themes that we're talking about in terms of the significance of the investigation and the significance of the work going on the front end. And one of them is that, as we were saying, when we're talking about mitigation, when we're talking about doing this multi-generational family background, what we're talking about, and as our 2 panelists said, is really providing the jury with as much information as we can to allow the jury to feel comfortable that they are making a considered decision, weighing all the relevant factors about whether or not this person should be put to death by the state. So all of that mitigation information is trying to give the jury the best opportunity to feel as though they can make that sort of weighty decision. If you have a mitigation case that's insufficient, if you don't have the resources devoted to being able to do that, what you end up with is cases that much later on, jurors will say, oh, well, if I had known that, that would have made a significant difference. I thought he was just evil. I didn't know about his schizophrenia, as Rob said, or something like that. So it has to do, right, with the trust we put into the system when we're asking our citizens to take on this incredibly weighty responsibility, which is to determine whether or not the state should take the life of another citizen. And then there's a separate part of this investigation and work, right, which goes into what we would call in the industry, what we would call fact investigation, right? And that's all the work that needs to go into understanding also the guilt phase of the case, understanding what exactly happened. Is it possible that this client is being wrongly accused? And is this client maybe going to be wrongly convicted? There are different aspects of the process that we need to feel like we have all the information that we can dig through and provide to feel confidence in the system. And these are both areas that are dependent on good attorneys, good staff, good resources, but that's why you need to do both, right? Both to have confidence in the outcome because of maybe questions about guilt, innocence, but also questions about just, do I feel comfortable sentencing this person to be killed? So I just wanted to focus in to make sure to draw out those two threads, because now we're going to move to the process, which is you've had your trial, whatever the trial may have been, good attorney, bad attorney. Let's say you had sort of what we see as typical, a mediocre, a middling representation. Maybe they didn't miss all the issues, but they missed some of the issues, certainly, and you're going to go through an appeals process that we know takes a long time. Everyone's sort of familiar with that colloquially. Oh, death penalty cases take forever. But I think there is an assumption that because the cases take so long, there must be a lot of scrutiny being given, and the length of time has to be somehow related to the thoroughness of the reinvestigation of the case, which I think you're both going to have some things to say about. But why don't we just describe, just at the outset, Emily, you said there are so many roadblocks. So can you start by just describing what exactly those roadblocks are?
Sure. Well, I'll give you a few of them. Again, I don't want to take up the rest of the hour talking because I could with these. So it's important to remember that once you're convicted and sentenced to death, you're no longer presumed innocent. You are in fact going to be presumed guilty and that both the guilt and the death sentence were correct. And everything in the process from here on out, so the trial is just the very early stage of your case. Everything that's going to happen over the next years to decades in your case is going to be designed to keep that conviction and death sentence in place. And the way that is done is primarily through very strict and arcane procedural rules that set forth heavy requirements that you have to meet. And when I say you, I'm really talking about your lawyer. It's requirements that your lawyer has to meet because you're on death row, and your ability to challenge your own conviction and death sentence from death row is almost non-existent. You have to have an advocate on the outside who can follow these rules, help you navigate the process, who can conduct additional investigation, make complicated legal arguments. And right from the bat, you have one major roadblock is that anything that your lawyer does is attributed to you. And so starting from trial, but continuing on, if your lawyer makes a mistake, that is considered to be your mistake, even though you are on death row now. And you may not have any ability to reach out to your lawyer, to talk to your lawyer. You may send letters that are never answered. You may try to set up phone calls that never happen. And if your lawyer doesn't do what he or she needs to do and file the right claims, meet the right deadlines, then that's your fault in the eyes of the law. And that's a huge problem. The next big thing that plays into that is that there are so many deadlines and very technical requirements that you have to meet, especially as you get further along in the process. And those are really absolute, that if you miss one of those deadlines, if you miscalculate a date, even the court isn't going to look at your case. It's not going to look at your claims. Another major issue is as you get further along in the process, you actually have no right to counsel. This is something that often really surprises people, that you lose your constitutional right to counsel fairly or early on in the process. You'll go through something called a direct appeal, where the court kind of looks at what happened at the trial just based on the trial record and says, okay, I think these rulings from the judge were fair and this is a proportional death sentence, so I'm going to uphold it. And once that's done, you no longer have a right to an attorney. And that means that if you want to bring in new evidence that you're innocent, that you have some constitutional reason why you can't be executed, why your trial counsel was constitutionally inadequate, you have no right to an attorney who can help you bring those claims under the US Constitution. So that's another huge roadblock. And what ends up happening, and this is probably clear from kind of how I'm describing this, is that all these years of litigation end up being about procedure. They end up being about whether or not something was filed timely, or whether an untimely filing can be excused, or whether a prior attorney's failure to raise a claim can be excused or should be blamed on the defendant. And very rarely is the court actually looking at the underlying claim. Is this person actually innocent? Is this person intellectually disabled? Did they receive inadequate representation at trial? Instead, it's years and years and years of fighting about process. And when I actually teach a habeas course at Georgetown Law School, and when I teach it, I think some of my students are a little dismayed to find out that we're not going to be spending the entire semester talking about how to prove your client is innocent and things like that. No, we're talking about procedure. We spend at least half the semester talking about procedure because that's what representation often is about after a conviction occurs. And that means that all those years, and there's other things that cause delays, and maybe I can have Rob talk about some of those as well, but in terms of the actual time the court spends looking at the case, so much of that is just about these technical procedural aspects of habeas law that really aren't about the underlying case and don't really have anything to do with the crime or the defendant.
You know, and there's some other, it may seem strange to some folks, but having a mediocre lawyer in these cases is worse than having no lawyer at all. And that's because of the way appellate review works. We have the most common ground that a death penalty case gets overturned is a finding that counsel was ineffective. And the defendant has to prove that he or she received deficient representation, objectively unreasonable representation, and that there was a reasonable probability the outcome would be different. The problem with showing deficient representation is that it often has to come down to showing that there was no strategic reason for what counsel did. And a mediocre lawyer will have a strategic reason for what he or she didn't do. They'll just have done it badly. And that means that essentially, if you got someone who did nothing, you'd be more likely to get your case overturned than the typical poor representation that we see that's a product of not enough time, or a product of not enough resources, or a product of not enough thinking, or a product of not having the investigative resources to have discovered some facts that you wanted to discover but didn't discover. That is what we see over and over and over again. And among the people who've been executed most recently, most of them have had very significant claims of constitutional error. Several of them, I think, were unquestionably innocent. But because they were provided bad enough lawyers for a long enough period of time, they were not able to get the courts to consider their views, to consider their issues. There's another thing that's also important to understand, and that is the worse a case is, the more horrifying it is, the worse the evidence tends to be. You have part of that's because of public pressure. Part of that is because people are just horrified, and prosecutors are trying to do what they can to put away the person that they think did it. Oftentimes they're wrong. Oftentimes what we see is that someone is arrested as a product of tunnel vision. But when you have this worse evidence, there are going to be more types of errors that take place. But the way appellate review works, you've got to show that the error was not harmless. And when the facts are horrible, courts are much more likely to say that it's harmless in light of everything else. When in reality, you have one house of cards here, and one error laid on top of another error, laid on top of another error, laid on top of another error. And in the misconduct case, in the bad evidence cases, you're more likely to see prosecutorial misconduct or police misconduct. And when that's involved, you're more likely to see the police or the prosecutors hiding evidence. Police sometimes hiding it from the prosecutors. And when that happens, when you don't have properly resourced counsel, it's almost impossible to find that evidence. So a lot of it comes up at the last minute at a time in which the standard of review is so horrible for the defense that they're not able to either get review or get relief. Once you've gone through your first stage of the appeals, if the evidence has been hidden long enough, you've got to prove actual innocence before you're able to get a court to hear your claim. And to prove actual innocence, you've got to show that no reasonable juror would ever have convicted. That's almost impossible, because there could be junk evidence that the juror could have relied on. There could have been something that was found to have been harmless error, but was still error, and there could have multiple layers of them. So you end up with innocent people being executed. You end up with people with clearly unfair trials being unable to present that evidence. And you end up with people who, if the jury had heard facts about their lives, would have returned a life sentence. But because the information was withheld, or because the records were unavailable for a long time, never got in front of the courts. We've seen that there are fewer and fewer executions, fewer and fewer death sentences these days. But the ones that are being carried out are the ones that have involved the worst evidence. They're the ones that have been the least fair, and which have had the worst of the worst in the way of process. But all these procedural hurdles, all these technical rules that are present in the habeas corpus process make it so that we can't have confidence in the outcome of these executions.
So one question that I bet is on a lot of people's minds who are listening to this is why, right? Like, why do they make it so difficult? Why is the system so difficult? If we're going to have a death penalty system, why are we putting all these roadblocks in place? And obviously there's going to be some speculation that I'm asking you to engage in to address this, but there are also, I think, some things we can point to for what the reasoning is behind this and how we get around that. So what is the purpose of making this process so difficult?
I think the process does exactly what it's been intended to do. I think that the legislators who saw that people were getting death sentences overturned didn't want death sentences to be overturned. And they had political interests that were divorced from the interests of the judicial process, which is to be fair, to be truthful, and provide accurate outcomes. These are result-oriented statutes, and they produce the results that they intend to produce.
The other thing about why is because it's expensive, because it costs a lot of money to do things right. And there are a lot of states that have decided to get rid of the death penalty for that very reason, but unfortunately there are a number that have retained it, but been unwilling to invest the resources to ensure fair trials. And that's where you get into trouble. The American Bar Association, the ABA does not take a position on the death penalty for or against, but it says if you are going to have the death penalty, you need to invest the resources so that there's fairness and due process. And that's what's really lacking in a lot of places. So I don't disagree with what Rob's saying, but I think there's an additional political layer on top of it, which is that it's unpopular to spend a lot of money on lawyers for people on death row or people accused of capital crimes. And the result is that you have a long, torturous process that doesn't actually get to the truth of the matter in cases.
And I think California is a perfect example. In California, when you have inadequate resourcing at the county level for capital defendants, for defendants across the board, and then when you get to capital appeals, the state pays so little that you don't have enough qualified lawyers who are willing to handle the cases. All the recent death row direct appeals, as the first stage of the appellate process, that have come down to California have been 17, 18, 20, 25 years before the defendant even gets to that level. And that's the point, you're still stuck with the issues that were raised at trial. When it comes to then having to investigate new issues, you've got to wait years, literally years. In some cases, people have been waiting decades for a post-conviction lawyer to be appointed. And you can get people on death row 30, 40 years, and they haven't had all their issues heard. Now, that could be rectified if the California legislature wanted to spend $1 billion to provide the money for counsel. But there is no political will to do that. The legislature, in fact, doesn't want to have the kind of death penalty system that would be one that produces fair process. It's not that they want unfair process. They don't want to pay the cost. They don't think the taxpayers are willing to pay the cost. And that's why you end up with things like Proposition 66, which gives false promises of being able to speed up the process and has, in fact, only led to additional litigation that's further delayed the cases.
So I think what 2 points to really take away from this. First, in talking about the length of time that the capital cases are taking, I think we can all agree, right, that the length of time that the capital case takes to get to whatever the resolution may be is not indicative of how much the case has been heard, how much process has been given to an individual defendant. It can be a number of things, like Rob, as you were saying, if you're in a state like California, where it can just take so long to be able to find the next attorney who is qualified to take on this case, who is able to take that case. If it can take 20 years for that attorney to become available to do the first stage in the appeal, that's the first 20 years of the case, right? That's not 20 years that the case has been painstakingly investigated and reviewed. That's just waiting for the process to move on to the next step. And then also in terms of cost, what I'm hearing, and this isn't, I think, going to be a surprise to anyone, but basically that the better you want the process to run, if you want the process to get things right and uncover the sorts of information we're talking about, you need to pay for it. And if you don't pay for it, you're not going to be able to uncover these kinds of things. And then if you have that issue combined with all of the structural impediments that we're talking about and how just generally difficult it is to get a case heard and assessed properly, you're going to end up in a situation where you have wrongful convictions, either for reasons of innocence or just for reasons of a patently unconstitutional aspect to the trial, to the case, getting carried through all the way through to the process. So I just wanted to really drill down on those two myths, because I think it's really important to emphasize what cost and time actually mean in death penalty cases.
And Laura, the myth is the more time, the better the outcome. And the myth is that the defendant has every incentive to delay the process and try to drag it out. But it's taking 2, 3, and in some instances 4 decades to exonerate people. So it isn't that the defendants are delaying it; it's that there are kinks throughout the process. The more time, better result. That's like saying when your plane gets diverted so it doesn't meet you at the airport, the fact that it took you longer to go home means that you had a better travel day. I mean, it's complete nonsense. The amount of time you spend in the system has nothing to do with the extent or the quality of the review.
There was a case that we worked on at the ABA several years ago that I thought illustrated this painfully but very well. And it was a case out of Missouri where the defendant was convicted of a capital crime in 1999, and he was intellectually disabled. And in 2002, the U.S. Supreme Court said, if you're intellectually disabled, you are categorically ineligible for the death penalty, full stop. And that was a claim that his lawyers could have raised in the post-conviction or habeas proceedings. That would have been the proper place to raise that claim. But his lawyers actually didn't even meet with him for more than a month, for over a year after they were appointed. And the first time they met with him was a month after the filing deadline had already passed. They ended up filing their petition 115 days late. Which, like I said, even if it was 1 day late, it would have been too late. 115 days, it was egregiously late. And for years, nothing happened with that case. And it wasn't until very late in the process that some different lawyers came in and said, wow, there is a slam dunk claim here that this person is ineligible for the death penalty. And it had to go all the way up to the US Supreme Court to get those new lawyers on the case. The original lawyers refused to get off. The Supreme Court said, no, you get some new lawyers for at least a chance. And the courts ultimately said, no, this was a missed claim. It should have been filed on time. The fact that it wasn't filed on time is the client's fault, of course, because the lawyer's mistakes are imputed to the client. And this case spanned 17 years, 3 months, and 17 days. So over 17 years, the only time that any sort of hearing was held on whether or not this person was eligible for execution was 11 days before he was killed. And counsel was given 40 hours notice before that hearing was held. So 17 plus years of time in one case was really less than 2 weeks. And the lawyers weren't even given enough notice to be able to be there to attend the hearing. So every time I hear someone say, well, capital cases take such a long time, what are we doing? This is ridiculous. They've had so much review, so much process. I think about this case and how the total amount of time from conviction to execution really is often a lie. It really provides a false impression of what the capital punishment system is and what the review process is. Because so much of it, like Rob said, is waiting around for appointment of lawyers, waiting for courts to file, or having your own lawyers not do what they need to do. And the result is that courts never hear the merits of your claims.
And I want to just get to, because I know we're coming up on when I want to switch to audience questions, but before I do that, and I think this is actually getting to one of the questions that I'm sort of seeing out of the corner of my eye coming through the Q&As, and that is, are there solutions to these problems? Okay, we've identified the problems. Are there ways to fix it? And I also want to be cognizant in asking that question that one of the things that we've addressed is the fact that the process is very different in different states and different jurisdictions, right? So we have to be aware of the fact that any solution, you can't just say we're going to have a nationwide solution to this problem. This is state, and as Rob was also saying, county dependent in a lot of cases. So keep in mind, I guess, participants, when you're listening for the answer to this, whatever the sort of recommended broad changes are would have to be adopted individually in many different places to actually take effect. And of course, there's going to be political will issues and different circumstances that come into play there. But so generally speaking, if we could make broad changes, what would need to happen to feel confident and in a death penalty system, in the death penalty process? Where do we need to make the changes, and what are they?
You know, this is not something to be answered in 1 minute,
You have
1
2
hour,
minutes.
or even a day. There are problems. Everything that's wrong with the criminal legal system is worse when it comes to capital punishment. And that's partly because of the emotion, and it's partly because of the stakes. It's partly because of the political benefits that prosecutors can reap from getting a high-profile conviction. And it's partly because the cases are just so complicated. I think there are a range of things. We haven't talked about juries. The jury selection process is inherently unfair in capital cases. You have to swear to be willing to cast the first stone before you can even be considered to be on a jury. And so people who could be fair in determining guilt or innocence don't get to be on the jury. And that may skew the outcome. We know that a death qualified jury, which is what it's called, is more likely to convict and more likely to convict of worse crimes. It's not just that it's not just problems with the jury. It's problems with the evidence. And again, the worse the case is, the poorer the quality of evidence is frequently permitted to be in there. So the innocence projects throughout the country have recommended a whole range of reforms with evidence, with better eyewitness, eliminating junk science, a whole bunch, eliminating the use of informants except in very narrow circumstances, and documenting the circumstances in which informants are used. That's only the beginning of it. There are a whole range of higher quality counsel that has to be afforded, more resources that have to be afforded, eliminating these procedural impediments to getting at the truth during the appellate process. I think one of the key reforms is getting rid of the habeas corpus statute as it's currently written, where right now you can only get relief if the state court has unreasonably misapplied law as already clearly articulated by the United States Supreme Court. The fact that you've made a harmful mistake in a death penalty case isn't enough. So I think you've got to look at things throughout the process. And the last part, but probably the most important part of the reforms, is that whether you get capitally charged depends less on what you did than who the prosecutor is in the county at the time that the crime is being prosecuted. And so if you want a fairer process, it's critical that you elect prosecutors who are committed to fairness and who believe that justice isn't convictions, justice is doing what's right.
Emily, unless you want to add, I will try to move through some of the audience questions now. Some of them are bigger.
I apologize for monopolizing that.
No, well said, Rob.
I'm gonna go with a short and sweet one that I think I have a feeling you'll be able to answer. Are federal capital habeas units a boon or a bane for those on death row? So what do we think about, as we call them, choose? Emily, I'm going to make you answer this.
Okay. We have pushed for the creation of choose capital habeas units. They are they fit very well into the model that is recommended by the ABA, where you have an office with skilled, experienced people and staff and auxiliary services that can provide representation at a very high quality level to people on death row. There are not enough of them. They're not in enough places. This is improving very slowly, but we're very happy to see some new CHUs opened in Texas recently. That was a big step forward, but they still are routinely maxed out on the number of cases that they can handle, and there are a number of issues that still come up. They are not the perfect solution. The way that there is still control, the CHUs are under the control of the judiciary because the federal defender system falls under the control of the judiciary. It falls within the judicial branch, is problematic. And there was a great study that was done a few years ago that it was a multi-year study convened by Chief Justice Roberts and conducted all over the country and put out a phenomenal report recommending some changes that would really elevate what the CHUs could do and the level of representation that they could provide. But if you want the quick and easy answer, CHUs good.
CHUs are good, and maybe an institutional defender general that would create even more independence. There are two types of CHUs in the United States right now. One are federal defender offices, another are community defender offices. The difference is one's a nonprofit and the other one is under the control of the courts. Both of them provide substantially better representation. And that's why we're seeing so many more of the injustices now at the execution level, because finally, after years and years and years, quality counsel have gotten involved in the cases. Unfortunately, because of the procedural hurdles, many of the issues are never heard. But as courts become familiar with what the issues should have been, what issues should have been raised, we've seen that in the jurisdictions that have CHUs, the quality of representation across the board begins to rise, and the quality of judicial review, as judges become accustomed to seeing the evidence they should have been seeing all along, that begins to rise as well. So CHUs are extraordinarily important, and they don't eliminate injustices, but they go a good long way towards enforcing the Constitution.
And another question, and we have several, I don't know that we'll be able to answer all of them, but just try to brevity with the answer so we can get through at least a few more of them, and I'll try to stop talking as much myself. Okay, is there more fairness in trials at the federal level under the Federal Death Penalty Act? And I suppose this is versus state. And I know it's going to be hard to give just a brief answer to this question, but I'm sure the federal death penalty is on a lot of people's minds. So I wanted to make sure we had an opportunity to just speak a little bit about the difference between federal and state death penalty systems.
No.
Thank you, Rob. That was perfect brevity.
No, there are more resources available at the federal level than there are at state levels. And studies have shown that defense counsel is provided half the amount of resources as other defense counsel, doubles the likelihood of a death sentence. So we know that there are all sorts of fairness issues based on resources, but half of all the death sentences in the federal system come from just 3 states, and we know that in a fairly administered system that would not be possible, and it's because there are states with a culture of death. The federal judges that come through that state system with a culture of death, they've had flexibility to appoint counsel. The counsel they pick are the ones who have come through the culture of death and done relatively poorly or mediocre. And so it's not surprising that it's Texas, that it's Virginia, that it's Missouri, the same states that we used to see extraordinary problems in providing counsel at the state level.
And another question, just talking about parity, do the constraints in staff and resources apply also to the prosecutor's office? This was something I wanted to ask about when we were talking about trials, so I'm glad this got brought in an audience question. So are prosecutors' offices having the same amount of trouble that defense offices are in having the resources to do their cases?
No.
I know this is my fault for asking for brevity. Can you please elaborate on that just a touch?
Oh, this is something that the ABA has, I couldn't even tell you how long ago we started pushing for this, a very long time ago, before I was a lawyer, of parity of resources between the defense counsel and state prosecutors. And that is not something that has come to pass. They do not have the same limitations. They don't have to go to the judge, for example, to ask for funding to conduct an investigation or get an evaluation done. And that makes an enormous difference in the way that they prosecute a case versus a defender defends a case.
And when's the last time you saw somebody in city council or state legislature say, crime is up, so let's increase funding for defense? That's not how it works. Crime is up, so let's increase money for policing, let's increase money for prosecution. And that's why I think it's one of the fundamental reforms that's necessary across the board at state level, federal level, is to treat justice as a product. And you have a budget for justice, and then that budget gets equitably distributed so that you have fair outcomes. As I said earlier, the justice doesn't mean convictions. Justice means getting it right.
Another question that I thought, I don't know if either of you will have easy answers, but could be interesting. Someone asked, when voting, it's so hard to find out information about prosecutors, judges, etc. How do we do proper research? So to the extent either of you have ideas, especially for people who are voting with the idea of capital punishment at the front of their minds, are there any good resources where people can make educated decisions? And I have to say, as a new Californian for the past few years myself, I too have had trouble trying to understand all of the different judicial positions I'm electing and trying to figure out how to do that. So there may not be an easy answer, but if you have any thoughts.
There is no easy answer. And because the rules are different in every state, and because you've got to find the information at the county level. It requires a lot of legwork if you're going to do it as an individual, almost impossible to do, or it requires the presence of public interest organizations that are doing some of the work for you. There are organizations like the Justice Collaborative, the Injustice Watch in Chicago. There are various nonprofits that are, the good government nonprofits. The bar associations try to do evaluations of the judges, but that's more towards whether they are qualified intellectually and ethically, not to the content of their beliefs. So it's a really hard one to answer.
And maybe that's something that we can think about just at Death Penalty Focus as a nonprofit in California, if that's something that people are really interested in, and especially now knowing what the ballot looks like in California versus in other places. It sounds like that's an area where research and support for voters and citizens could really be useful. So and
I will say, when it comes to prosecutors, it's becoming a little bit easier because as we see the current situation, there are many more people who are reform prosecutors who are running. And so people are paying more attention to decisions that are being made with respect to mass incarceration and the death penalty at the county level. So I think that will become easier as more people become aware of how much power the prosecutors have in just discretionary decisions that affect the entire trajectory of criminal law in a county.
Great. And that actually just perfectly opened the door to, I think, what will be the last question for the time we have budgeted, which is, would you ever recommend use of a statewide board to decide which cases would be prosecuted capitally? But basically, in terms of thinking about reforms, if we could cut down on the discretion of an individual prosecutor, let's say, would that be the kind of reform that could make the system more fair?
That depends on who's on the commission. There are a lot of these questions. Structure can only do so much. A body that makes decisions is only as good as the people who are on that body, only as ethical as the people who are on that body, and they reflect the political views of who's on that body. We're seeing that at the state level, with some of the reform prosecutors, governors and attorneys general are trying to take local autonomy away because they don't like the reforms. So I think that it can be helpful when you have complete differences in the way discretion is exercised. You can have a more uniform approach, but that doesn't necessarily mean the uniform approach is going to be the better approach.
And I see we have a question here also about how racism infects each stage of a capital case, which is such a significant question, such an important question. We're actually going to be doing a webinar on this topic. Death Penalty Focus will be doing a webinar on systemic racism in capital cases. We don't have a date or time set for that yet. We are working on that, and that information will come out to everyone who's signed up already to receive these emails. So I'm going to delay that question so that we can focus on it more broadly in its own topic.
Well, let me say that on September 15th, we will be releasing a report on the history of race and the death penalty in the United States, putting it in historical context and also within the context of the modern movement for criminal legal reform. So keep an eye out for that.
And if I can just put in a quick plug, Laura,
absolutely,
cut me off here. One of the things that we are focusing on at the ABA, since our focus is representation, is the importance of diversity in the capital defense team and the difference that makes in terms of being able to have a meaningful relationship with your client, given the stark racial disparities of who those clients are and who's on death row. And we're in the process of gathering a number of resources to help defense teams and the general public understand this issue a lot better. And that's something that we are going to be putting up on our website, hopefully very soon. So keep an eye out for that as well.
Wonderful. Thank you, Emily. And with that, I'm not going to take up more of everyone's time. I think we said about 70 minutes and we've come in there. I hope there's been some dispelling of myths or some information that people are learning for the first time that we were able to get at with this. Thank you so much, Emily and Rob, for doing this and having this conversation. I think it's so important to keep having opportunities to talk about these issues, even if they're very technical and very procedural. I think it is really important to learn. And thank you, Nancy, for giving us this platform to talk about this.
Thank you for having me.
Laura.
All right, we will, and Death Penalty Focus will be sending out emails announcing the additional webinars we have scheduled, including one that's going to be on systemic racism and capital cases and others. So thank you all so much.